Good morning. It's 12:15 p.m. on May 24th, 2021. I have a number of reports that have anniversaries today. I will be addressing those before 5 p.m. today. However, I want to take a short time frame to discuss matters and just put them succinctly for my own record, but also with an understanding that certain things have been revealed. I attempted to file with the Court of Appeals for the 5th District last week. I received confirmation of a account with the 5th District Court of Appeals through the electronic filing system on May 20th. I had composed an appeal that was ready by the day before. As a matter of fact, it was time-stamped for 3:16 p.m. However, I did not have a means by which to submit it until the next day. In an effort of trying to address during the day of the 20th, matters relating to a pending public comment period at the Federal Reserve, I ended up being what I understand to be electronically attacked, and it deleted all of the information I had been working on up until that point concerning my response to that public comment period. Public comment was due on May 21st, and it specifically regarded emergency lending to low and middle income community financial institutions. My context is, and I have been maintaining this since I was in a domestic violence shelter in February of 2016, that when it comes to emergency response, that it is not just enough to address factors in the moment as if it's a crisis, that there should be preparation that has already commenced, and that preparedness and prevention should be a part of ongoing daily activities, especially when you have the means by which to offer services to people in such a regard. I have a personal history of being a part of a program that was about emergency preparedness and prevention associated with the public health department. And what has been going on since the alleged COVID-19 pandemic onset, nobody's contacted me in this regard. Even if I don't have practical, literal, direct experience or certification or qualification to provide medical services, there is a great deal of administrative support that needs for commencement or needs to be occurring at this time in order to make sure that we are not actually creating more perils. But if, as I suspect and contend, it is not about a public health response to a pandemic, but is about something else, including an ulterior political agenda, then we are where we are. And I bring this up because in the context of composing that public comment to the Federal Reserve, I was trying to add context to demonstrate that there had been a means by which a particular methodology for understanding the underlying causes that could exacerbate a situation once it got to a point of an emergency need could have been prepared for or prevented by taking actions early on, and demonstrated that there was actually a timeline and actual provable demonstration of measures that could have been implemented at different times that were a specific kind of emergency to occur, including one that had already been anticipated based upon experience and observation of crime that had occurred concurrent to prior declarations of emergency. Then this would actually involve what I believe, and I'm not alone in this belief, would be an appropriate actual support for a community-based financial institution in an emergency situation, as opposed to just exploiting an emergency situation in order to accomplish ulterior financial goals. And that's exactly what I was compiling on that time frame. But somebody had coded my efforts to have put in some sort of what I call a terminating option based upon me submitting my motion to the Court of Appeals. And so when the time came for that motion that had been timestamped for 3:16 p.m. here, when it was 3:16 p.m. in Arizona, it ended up sending out an electronic pulse that I believe, depending on who you are, could potentially have been fatal. As a matter of fact, I've been witness before to people being at a computer and being hit with an electronic pulse comparable to what I experienced, and then having to have the ambulance called because they end up having a seizure. I was personally witness to this here in Dallas within the last 3 years. And so if it was meant to be terminal against me, then we are where we are. But what it did do is something that's happened before, which is it completely lost the record of what I had been working on up until that time. And what I'd been working on had been about taking things that I had already done and crafting what would have been, I believe, an appropriate response to that public comment, and then would have been a part of the public comment period within the required time frame, so that it could also be used as part of what these public comments are capable of. But at the same time, brings up a very, very practical question, which is, why have I been remanded to public comments at the Federal Reserve, as opposed to being able to be provided with a safe, verifiable evidence submissions process and the kind of support I need to prosecute crimes? And that was the essence of the report. However, that information was lost. I attempted to, shall we say, reestablish the intent by following through on it later. But in the course of trying to reestablish that intent and follow through on it later, I was exposed to other crimes that were going on concurrently on the night of the 20th to the 21st. And so what otherwise would have been available, even for a public comment period, to be able to circulate as a form of public currency or support, including information support that can be used as a form of currency or investment in the community, ended up being compromised, if not outright sabotaged, by virtue of the fact that what I was trying to do was being subjected to concurrent processes of sabotage. Intentionally misrepresented information was presented overnight in numerous electronic files and numerous electronic forums the night of the 20th through the 21st, including an inversion of policy decisions that had been made in the United States with specific regard to telecommunications and bans or sanctions on telecommunications from China. This is incredibly alarming, especially considering the context of the notes that had already been compiled were on my desktop regarding specific relationships between the United States and China and how that compounds factors related to what the intent of the public comment was, or at least alleged to be. Now, I say this as context because my understanding is that over the course of the last 3 days, several things have been revealed. My understanding is that somebody was, before I attempted to file with the Court of Appeals, somebody was using my cases as either insurance or some form of financing for some other litigious effort. And that in great deal of what it had to do with was a sort of transfer of assets concerning accounts associated with Citigroup to or through accounts associated with Bank of America. This is part of the pattern I've been investigating since 2016 actively. And this is part of what I would have sought assistance from the Department of Justice in continuing to investigate when I went on site to the Department of Justice in August of 2016 in Chicago. I've maintained my investigation. I still haven't received any follow-up. I still haven't received any support. I still haven't received any closeouts to any open files or open report numbers, including through federal agencies as well as through actual state agencies. And we are where we are. I've submitted 3 petitions to the Supreme Court of the United States. In the terms of what I was trying to appeal to the Fifth Circuit Court of Appeals, was a specific federal district filing that most recently had a motion issued, or rather a judgment order issued by the magistrate judge or alleged magistrate judge here in Dallas for March 15th that I understand was connected to a significant crime, and that something connected to that case was being used or abused at this time frame. I actually believe that what has been demonstrated substantiates my claim in that regard. But more than that, what it does is it also demonstrates that I had just cause claims in regards to the 3 petitions I had submitted to the Supreme Court of the United States. Inclusive in there was the first petition, which asked the court for assistance specifically with regards to acknowledging a request for quo warranto in regards to establishing who had the authority or who was responsible for the specific pattern of racketeering activity that was being demonstrated first practically and literally through my experiences in Texas that were themselves compounded by the fact that I had to come to Texas based upon the experiences I had had in Illinois, but that also elements of what I had been attempting to investigate, report on, and actually seek due process in regards to in Texas were appearing in the actual appropriations bills and processes that at that time were pending before the federal government in the form of HCon Res 71. There was a specific manner in which I named respondents concerning the manners in which they had voted on early aspects of HCon Res 71 and what I understood those vote counts meant in relation to the pattern of racketeering activity and how that correlated with concerns regarding the what I understood to be misrepresentation of metric representations that had specific implications, specifically regarding the transportation budget. And so I filed that. I was told over the phone by somebody on the phone that primarily that the court responds to writ of certiorari and they are going to send me back my original filing in the mail. However, my original filing in the mail was stolen after I'd been banned from the place where I was allowed to receive mail. My understanding is somebody's been using that for very, very illegal activity in or throughout, or at least based out of Houston, Texas ever since. This would have been stolen in December through January of 2017 to 18. Second, I filed the next year in 2018, I filed a second petition with the Supreme Court of the United States, specifically requesting a writ of certiorari in regards to, requesting consideration of charges regarding sedition concerning what had transpired since HCon Res 71 had been passed and had then been put into implementation during 2018. I listed specific respondents that were demonstrating a different element of the pattern. This was not to, shall we say, disacknowledge or to relinquish the first claim in the first petition against the named respondents and the specifics of the charges, which I contend still hold valid. But by the time it had been implemented and was allowed to be implemented and put into effect for the year of 2018, and based upon what was happening concurrently in the state of Texas, relative not only to matters related specifically to the state of Texas, but also federal representatives from the state of Texas, that there was a different demonstration of the promulgation of that pattern that was demonstrable if one considered it from those that were listed as respondents, and then identified that part of the allegations concerning the pattern of racketeering had to do with what was implied or what was demonstrable in regards to the reason why Secretary James Baker and former President Barack Obama were also identified in the manner they were as respondents to that second petition. I contend that what's been revealed in the last 3 days is that the charges in that specific effort to file with the Supreme Court absolutely support the charges from my third effort to file with the Supreme Court of the United States, which was in the beginning of 2020, after the United States Senate had proposed a bill regarding, among other things, mineral rights claims concerning land that had previously been held in a private trust and then had been transferred to the public trust. And how, after a 30-day period, the Senate passed it with a unanimous voice vote, and then referred it to the House of Representatives. And I contended that that bill revealed intentional, willful violations of the 13th Amendment, and that it was part of the ongoing pattern of racketeering activity in a very specific manner and potentially with harrowing implications, especially in consideration of what I had understood had come due or was also potentially able to be exploited as part of this pattern of racketeering activity. It was part of supplemental information I sent to the federal district court in a process that was not within the specifics of the electronic filing procedure, when I contacted a judge regarding access to claims in lands or via affiliation through tribal designation or through claims associated with the Cherokee Nations. Why? Because part of the pattern of racketeering that was going on the local level during 2019 correlated with elements of the efforts that were going on with the Texas State Senate that were also challenged in the federal district court specific to public education. And so that is a specific matter that I have not yet addressed in a motion, and I will not say anything about further until such time as I get to court. But the actual explicit charges that were mentioned and the actual explicit pattern of racketeering activity that was identified And the specific constitutional question under whose authority the president or Congress is has now been, I believe, clarified. Not only has it been clarified, but it has also answered another question regarding was it something that was going on at the behest of the state of Texas that was being promulgated onto the federal level? Or is it something that was being operationalized and approved or authorized at the federal level that was being kicked back, so to speak, or that was being used in conjunction with what was going on at the state level? I believe those questions specifically have been clarified, and that just cause claim exists for both petitions, both the one against the United States Senate and both the one against the Texas State Senate. Now, I contend that the Senate has a specific relationship here, especially considering what were the implications of, or what were the charges regarding the petition from January of 2020 that was sent to the Supreme Court with the 13th Amendment claim, and that this has actually been meted out, and that the events that occurred on Capitol Hill on January 6th of 2021 are actually evidentiary of that as well. Not only are they evidentiary of that as well, but they also have done something that was not anticipated at the onset, which is they've revealed another process that is going on concurrently. And it specifically speaks to miscalibration or misidentification or specific encoding with metrics, including in schemes that have persecutorial intentions or implications and that violate other constitutional amendments. And that this is the second demonstration in the last 2 years of a specific timeline that is aimed at effectuating through a form of constitutional violations, not only of rights to due process, but cruel and unusual punishment, including cruel and unusual punishment without there actually being a prosecution or access to rights to due process, in consideration of acts of anti-Semitism and also acts of ethnic cleansing that are masquerading as something else. And this is not something that I had specifically and explicitly anticipated or had identified. It was something I was concerned may potentially emerge as an indicator of the full profundity of these crimes. But I believe that's absolutely what was demonstrated over the weekend. And it's very harrowing and it's very concerning, but it also does fulfill what I understand would have been the requirements for actually considering the information that was first presented in my writ of habeas corpus concerning the bill of exception. And it also discusses and also demonstrates what the difference between a bill of exception is and an amicus curiae is. And so I believe that there is more than enough evidence to substantiate not only that I had just cause claims, but that there has been serious crime, including very comprehensive organized crime that has infiltrated the government, that has intentionally obstructed due process so as to attempt to not only escalate the risk associated with refusing to prosecute it, not only allowing for what should be efforts at criminal prosecution and or actual constitutional challenges, including ones that could have been considered within an appropriate administrative or legislative or appropriate adjudicative process through the legislature, had they been actually fulfilling their duties, constitutional duties to represent the people. It also could have been put through the judicial branch of government in order to be an investment in the people and supporting us in our rights to due process, including in consideration of constitutional issues that may be novel or may not have been considered in light of other constitutional issues that have been allowed to take priority for the last 10 to 20 years. But it also demonstrates that in the course of these matters being allowed to promulgate, that the intent of those that were obstructing them were also in abuse of their powers, including their high powers of office, both in the state of Texas, but also in the federal government, in order to try to mischaracterize crime as something that could be covered up under the auspices of alleged national security. I contend it's absolutely the opposite. They've been abusing the protections of alleged national security, including things that would allow for things to be called classified, and especially abusing concepts and what legal definitions of confidential are in order to try to underwrite their crime. And it's unacceptable. It's the people of the United States of America are the ones that give authority to the government. All power comes from the people. We've already had at least one, if not several, demonstrations of how the government has failed to do its duties to represent us The question then becomes, in whose interest are they attempting to participate in whatever it is that is going on in the stead of actually representing us and our constitutional rights. But more than that, the specific tactical and practical course of action that is going to occur now in order to try to address these egregious breaches of the Constitution, I contend that we have engaged in a process that has put us into a situation of political bankruptcy. But the problem that is actually occurring is very much important to the original considerations of, well, who had the credibility to begin with? Whose credit was it? Whose country was it? And it wasn't the people that abused their office in order to engage in intentionally unconstitutional proceedings with or for whatever reason they decided in order to try to compel us to cede on our rights, including our rights as citizens or future citizens, so that we could be illegally expropriated for completely unconstitutional reasons in order to extort us into cooperating with grave crimes. I intend to follow through on this. The means by which it can be accomplished, I believe, has already been demonstrated. Among other things, the specific request I made for a new trial, or leave to file motion for a new trial, also called into consideration aspersions that were cast on my capacity to follow through in terms of being able to sustain a financial commitment, a legitimate, good faith, legal, financial commitment to follow through on what would be needed in order to effectively prosecute these crimes that had been presented before first the Supreme Court of Texas in regards to request for consideration and the fact that I had been requested to file or needed to file an affidavit of pauperdom in order to move forward on criminal charges or in any sort of effort at due process. And the manner not only in which the Supreme Court of Texas addressed that, but also the manners in which the Federal District Court addressed that, and how other people abusing their political office, including in connection with people from other sectors outside of the government, have denied and obstructed due process while using what should have been used for due process in the commission of crimes. Insofar as there's any justification that there was a military use value, please understand I already contacted the Municipal Security Rulemaking Board directly in April of 2019 about that very specific matter. And I've been denied absolutely any contact with any actual, literal, official military organization or anybody willing to identify themselves in a military chain of command. That includes efforts to contact the Department of Defense directly. And insofar as that's the situation, then the understanding is, constitutionally speaking, even the military is under a civilian authority. And if there's so much overwhelming evidence that those alleging that they qualify for the protections accorded to those in performance of their official government duties, then it is actually on them to correct for the abuses that have occurred in connection with any justification that this has anything to do with the military, up to and including illegal contract bidding in consideration of Department of Defense contracts, and up to and including misuse or misappropriation of what should have been able to be pursued through the judicial process by anybody alleging that they have the cover of the National Security Administration and or any sort of intelligence operations, including the DIA, the CIA, or any other sort of efforts to try to bury this or subsume this within the Department of State. Specifically in regards to matters related to the implications of the original charges in the petition for a writ of habeas corpus concerning the allegations that people were being used or being trafficked in connection with illegal practices that were ongoing at domestic violence shelters and the implications. It is very, very important that this not be allowed to be something that is exploited by those attempting to claim they have the cover of the Department of State. This is something that we are still dealing with from a very long time ago, and it also is backing up what I'm concerned is going to be potentially a third demonstration of the very comprehensive pattern that had not originally been anticipated, but if I'm correct, is anticipated as coming due before the end of this calendar year. On the other hand, I need personal support, including with people that are trained legal professionals and or people that feel that they are competent, capable, and willing to take responsibility for representing themselves pro se. And I need to have a safe evidence submissions process. I need to have verification that it is going to be appropriately bonded in consideration of the important roles that sureties and financing plays in assuring that these processes are taken under consideration in a correct manner. And I'm going to need human support, including access to people that have verifiable experience in military JAG law in order to help distinguish between what is an appropriate legal process and what are necessary protections for civilians against abuses by those claiming they're operating under the rubric of the military.